Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So wouldn't you know it, I took my first real break from YouTube in like 13 years. Took a trip up to the mountains, had absolutely no service whatsoever. It was nice to step away, come back and find out that while I was gone, the Ninth Circuit issued a major decision and gave us a huge win in a big 2A case out of the state of California. This is the case of Nguyen v. Bonta. This case is so big that it could actually have an effect on a bill that California is trying to push through right now. So let's talk about what's going on. Now, real quick before we get started, if you enjoy content like this, you're not yet subscribed, consider hitting that subscribe button. It really helps us out here quite a bit, and it helps us spread our Second Amendment advocacy. Also, if you're subscribed to the channel, make sure you're still subscribed to the channel because they've been up to some weird stuff lately. So again, double check that you're still subscribed. With that being said, let's get into this victory. Okay, so let's go and talk about what's going on with this major victory at the Ninth Circuit in Nguyen v. Bonta. Now, this is a case that we have talked about a lot throughout the years because it is so important. This is the case that challenges California's 1 in 30 law. It's basically a law that says you're only allowed to acquire one firearm every 30 days. That is clearly unconstitutional. You're not allowed to limit somebody's constitutionally protected activity. So the lawsuit was filed at the district court. The district judge actually found that in fact it is unconstitutional and placed an injunction against enforcement of that law. Well, California appealed that decision and they wanted an emergency stay placed by the Ninth Circuit. And believe it or not, that emergency stay was granted, halting the judge's injunction. Now, that was just that emergency stay. Then went to another 3-judge panel who found that in fact the plaintiffs in this case, being Nguyen and the FPC and the other plaintiffs, actually had a likelihood of success on the merits, overturned the previous Ninth Circuit decision granting the stay and allowed the district court's injunction to stand. So that's why right now, as it stands, you are able to get as many as you want within a 30-day period. That's because of that district court injunction. Well, obviously, that's just an injunction, right? The case still has to continue. And it did continue as California appealed to the Ninth Circuit. And the Ninth Circuit had heard oral arguments and just yesterday came out with their decision siding with the Second Amendment. I honestly couldn't believe it. So if you watch the channel often, you know that California is actually trying to pass a new bill right now that would further restrict the number in which you'd be able to acquire in a month. This new number is 3, and this bill's already gone from one house to the other. It's gone through multiple committees, and it's making its way to a final vote and then the governor's desk. Thankfully, the language in this majority opinion from the Ninth Circuit Court of Appeals basically puts a stop to that notion that you could somehow limit what somebody can get in a given month. So the Ninth Circuit actually wrote, affirming the district court's summary judgment in favor of plaintiffs, the panel held that California's 1 gun a month law, which prohibits most people from buying more than one firearm in a 30-day period, facially violates the Second Amendment. Now, they continue to write, the panel held that California's law is facially unconstitutional because the plain text of the Second Amendment protects the possession of multiple firearms and protects against meaningful constraints on the acquisition of firearms through purchase. Next, the panel held that California's law is not supported by this nation's tradition of firearms regulation. Bruin requires a historical analog, not a historical twin, for a modern firearm regulation to pass muster. Here, the historical record does not even establish a historical cousin for California's 1 gun a month law. Now, this is where things get really interesting because this is language you don't typically hear from the Ninth Circuit, but it also shows you just how bad California really is, where it says California suggests that the Second Amendment only guarantees a right to possess a single firearm, and that plaintiffs have not had their rights infringed because they already possess at least one. California is wrong. The Second Amendment protects the right of the people to, quote, keep and bear arms, end quote, plural. This guarantees the individual right to possess and carry weapons. And not only is quote unquote arms stated in plural, but this term refers to more than just guns. It includes other weapons and instruments used for defense. California's interpretation would mean that the Second Amendment only protects possession of a single weapon of any kind. There is no basis for interpreting the constitutional text in this way. Now, this is the part that I think is going to affect California's new bill that would restrict you to 3. It says the Second Amendment expressly protects the right to possess multiple arms. It also protects meaningful constraints on the right to acquire arms, because otherwise the right to keep and bear would be hollow. And while Bruin does not require a historical twin for a modern firearm regulation to pass muster, here the historical record does not even establish a historical cousin for California's one-a-month law. Now, you and I already know that what California was doing was completely unconstitutional, but the Ninth Circuit will typically twist and bend Supreme Court precedent or twist and bend the law just a little bit in order to side with the state. So it was surprising when they came out with language like this. The Second Amendment gets treated like a second-class right all across this country. If California tried to limit the amount of times you were able to go to church in a month to 1, or limit the number of Bibles you were able to get in a month to 1, nobody would stand for it. If there was a speech issue, nobody would stand for it. But for some reason, the Second Amendment gets treated like this. So again, it's nice to see that the Ninth Circuit actually saw that what California is doing here is totally unconstitutional, and says that you can't limit the number that somebody gets in a given month. You're not allowed to do that. So essentially, the new bill that's coming out is done for. California can still appeal. There's still another appeals process, and they can, take this all the way up to the Supreme Court if they want. But the fact that the Ninth Circuit said there's not even a historical cousin here leads me to believe that this is probably the end of the road for Nguyen v. Bonta. So as of right now, that's it. California's 1 in 30 law completely struck down, and I wanted to share that with you. I was really excited to see that when I came back. I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, hit that subscribe button. Little like button is always appreciated, and that alarm bell will let you know when new videos come out. Sorry about the voice. You guys have a good one.